Hello, how are you doing? Welcome to Lawyers Infohub. It's always a pleasure to create content here. You're welcome. This is Lawyers Infohub, a platform where we create law content, we talk about law, we share experiences, aim at helping you become a better lawyer, a better law student. We bring in people to share their own experiences to help you, you know, attain excellence that you deserve. So today we're looking at visit to Locus Inco. As a law student, you might come across this in your criminal law. Um, as a law student at the law school, you might also come and meet this topic in the criminal litigation. Then, as a lawyer, you meet it in the course of the practical aspect of law practice. In the case you're handling, or in the case against your client, so it's important you understand the procedure, what is the rationale, why must it happen, and if there's need for you to object to it. Now, what is locus info? Locus info can also mean scene of crime. It's a place where the issue was erupted, or where the issue the reason why you're in court emanated from. It can also be known as scene of crime, the locus info. Some other time it can this term is used both in the civil and in the criminal proceedings. For example, in the civil proceedings, maybe issue of land, and someone is claiming this is what was on the land before you came in, and somebody say no, I met the land bare, or someone will say, okay, I erected some structures on the land, and someone will say no, and some I came to that land, there were no structures, and you say, okay, my lord, come and see if actually this land is bare, or there's something on the land before this person maybe first passed into the land. Or I'm just giving an example. So the court, you know, will then decide whether granting an application for locus inquiry is important, or it is very essential at that stage of proceedings. This application for locus inquiry, you can bring it up at any time in court. It's now left for the other party either to object to it or not to object to it, and the court will rule on it, or whether it is important that I visit the place of the crime, the scene of the crime. It's important I visit the place to know exactly what's happening, or whether I can sit in my court and still, you know, decipher whether the claimant is saying the truth or the defendant is saying the truth. So we are going to look at the procedure and why there should be a visit to locus info. It's very, 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 very germane. Yeah. So I earlier said that both in civil and criminal proceedings, that could be a call for the physical observation of a place, the scene of crime, rather than just the court listening to witnesses give their evidence, in order to, resolve a dispute that has been presented to the court. Now, a visit to locus info can happen at any point in the legal procedure, but most of the time there's been an argument that it should happen during trial, or it can come up during trial, because this is at that point you're trying to resolve the issue by giving of evidence. So many people have argued that it shouldn't come later than during trial. But we must note that it is at the discretion of the court. You cannot force the court to go to visit the locus. It is at the discretion of what? Of the court. The court will consider whether that visit will help in resolving the issue, which cannot be resolved by mere listening to the witnesses. And it's also important that the court can also, in its wisdom, state that a visit to the locus will be, an unproductive venture. So at that point, the court will say, I won't grant this application, but I think I can resolve these issues here. Now, what is the procedure for a visit to locus info? Look at Section 127 of the Evidence Act, which makes provisions for a visit to locus info. You see, there are two options when the court wants to, visit the locus. There are two options that the court can take, either option A or option B. The first option is that the court may adjourn to that place and continue the proceedings there. When the court adjourns to that place to continue proceedings there, the plaintiff must be there, or the claimant or the accused or the defendant, they must be there. It's not what happens in the absence of a party. both parties also must be there. And and witnesses who shall also testify at the locus. Yes, this is where the court adjourns and continues these proceedings. There, the witnesses also have to what continue with their testimony at that point. Another procedure is that the court may just adjourn, visit the locus, and come back and what proceed with this trial or these proceedings in the courtroom. Now, in this second option, the evidence, when the court just visits and returns to its court, the evidence of what happened at the locus will be given in the court. The witnesses that are there, the parties that are there will be allowed to give evidence of what transpired at the locus. It is very important. So this procedure is key. Whether the court adjourns to that place to continue or the court adjourns, visits the locus, and when it returns, if the witnesses who witnessed or what transpired at the locus will be allowed to give evidence, and that evidence will be cross-examined by the other party. So it's important that this procedure is what undertaken this way. You just can't go to the locus and come back. The parties who went there must also give evidence. Then the court will also take note of what it saw. The court will take note of what it saw. So we've seen instances where the court just makes a mention of what transpired by its own record during judgment. Many people have said, it's not right. The Court of Appeal and the Supreme Court have heard that if it does not it does not cause miscarriage of justice on any of the parties, it can fly. But the fact that the witnesses who went there who saw what transpired must be given the opportunity to give evidence of what transpired. Now, non-compliance with the procedure of this visit to locus, just like earlier told you, will not nullify the procedure unless you can prove the accused person or the claimant or whoever will claim that this non-compliance with the procedure is causing a miscarriage of justice. That is when this non-compliance can nullify the visit to locus input. Just like I earlier told you that there's no statutory time allocated to embark on a visit to locus input. It can be taken at any stage of the proceedings, just as I told you, even though there's been a kind of a dichotomy on when it should go. But there's basically no time for a visit to locus input. When there is a dispute to be resolved, it could be when a witness is testifying under examination in chief, cross-examination. It can come out that there is need for the court to go see what I'm saying. There's need for the court to go and visit this particular place. Then the court will wait, and the court also by itself so much can say, I need to go and visit that place. I need to go and visit that house. I need to go and visit that land. I need to go and see this place you're talking about to have a view of what actually that place looks like. And from there, the court will also make record of what it saw. So it is important we note all this. It can be taken at any stage. The court can, by itself, so moto on application of parties, visit the locus input to clear accuracy of a piece of evidence, where that evidence is in conflict with another piece of evidence. Now, it's very, very important for you to know that when a trial judge undertakes to visit the locus input, it is not proper for him to treat his perception at the scene of the crime or at the scene as a finding of fact. When a judge visits the scene and what the judge has seen, the perception, it is not right for the judge to just treat it, that's his perception or what he has seen as a finding of fact without evidence of such perception being given by a witness. That's why I said that witnesses that were in that inspection will be allowed to give evidence of what transpired. So we should now corroborate the perception of the judge. So the judge cannot by itself take his perception of what he or she saw at that place as a finding of fact without any evidence of such perception being given by a witness either at the locus or later in court after the inspection. This is very, 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 very key. Very key. Very, very key. Just like I also stated too, on the visit to a locus, the court should take record of the proceedings of what transpired. But when he fails to do so, if the court fails to take notice or record of what transpired, a statement of what transpired when he makes it in his judgment will be taken as an accurate account. So where the court returns and felt I don't need to give a separate account of what transpired, I will inculcate my statement of what transpired in my judgment. It is also accurate. It is also accurate. Um, Unless the other party can prove to the contrary that there was a miscarriage of justice by that. Now, I also stated earlier that when a visit to the locus people has been made, um, the evidence of witnesses may be received at the scene. That is, you don't know that two ways the locus can happen. Visit the locus can happen. I told you that the court can adjourn there and proceed, or the court will just adjourn, visit, and return back to its court where it's seated. So, when a visit is made, evidence of witnesses may be received either at the scene of the place, that's the locus, or later in court. But parties, must be given that opportunity, of hearing the evidence of witnesses, which can lead to cross-examination and commenting on the evidence. It's very important to understand this. Visit to locus equal is something that sometimes has caused a lot of back and forth by lawyers, understanding which procedure should be followed, and most at times the court, when the court does it so moto, another party is saying, okay, why should the court do it so moto? Is there an issue to be resolved? So it has been back and forth, but it's important to understand the procedure, how it can happen, what happens, what can be done after it is done, after you return from the locus, and how the court can, take its perception. When there is no, the court cannot by itself take its perception as a finding of fact when there is no evidence or witness corroborating that perception. So I just hope you'll be able to learn something about visit the locus inco. So when you hear locus inco, it means the place of the scene or of crime, the place that the transaction or the issue, leaves the court suit arose. It just is the or people just take it as a scene of crime. That is where the whole issue arose. So the court can by itself go. It can also go on application of counsel. Such application can also be opposed. So either way, when the court says I'm going, this is the procedure that has to happen. And when the court returns, what can happen? We have stated all that in this class today. And I hope you learned something. If you get to subscribe to the channel, please do hit the subscribe button, share the video, drop your comments. We'll answer them. If they are questions, share the video to someone else who might need to hear what we have just said. Thank you very much. Thank you very much for all my returning subscribers. I'm really grateful. For you who's watching me for the first time, please be a part of us. Click the subscribe button, join us so that you can get notification whenever we are live. Thank you very much.